This is Final Exit Networks. You're suing me because I kept your mom alive. Sounds strange. It's the wrongful prolongation of life lawsuits. And I'm here before I die, New Mexico Festival on Zoom virtually. I'm sorry, I love being in Albuquerque, but maybe next year. As I said, I'm Final Exit surrogate consultant, and I help surrogates and healthcare power of attorneys who may be having trouble enforcing an advance directive by letting them know their legal rights and giving them in the moment guidance. Like they can call me from an ICU or emergency room and I answer the phone and I can help them out. Final Exit Network's vision, it's a mostly volunteer nonprofit. And I mean volunteer. There's like only 2 paid people. I'm a paid consultant, but there's only a couple of people like me. Everybody else is a volunteer. And they exist to help people understand their rights and choices and to guide and empower them to make the decisions that work best for them. They don't really push you into any particular path. They just help explore options, which is kind of where I come in with this presentation. Ben believes that while death is not a choice, how you die should be up to the individual. They're all about choice. Their mission is to educate qualified individuals in practical, peaceful ways to end their lives, offer a compassionate bedside presence, and defend their right to choose. They're all about education, options, choices. If you go on their website, they have many, many places where you can click on a webinar, go on a YouTube video. They're all about education. And that's really mostly what I do, educating surrogates, educating other members. So today I'm going to discuss cases that illustrate the consequences if providers ignore your advance directive or your surrogate's instructions. I do other presentations about, how to pick a good surrogate and why you need an advance directive, but this one, I try to stay focused on cases that are so egregious, really, that providers just did what they wanted to do. And so that's pretty much what I'm going to talk about today. An advance directive is really 2 forms together. It's a living will, and it's a choice of surrogate, healthcare power of attorney. Every state is different, however they do it, but that's what an advance directive is. It's those 2 components. Every competent adult over the age of 18 can and should have an advance directive. And that includes teenagers right up to senior citizens, everybody in between, because you never know when a crisis is going to happen. You could be in a car accident and be in a coma, and then what? Who gets to choose what happens to you? 3 of the biggest end-of-life cases involved young women in their 20s. Excuse me. Karen Ann Quinlan, Nancy Cruzan, and Terry Schiavo were all in a persistent vegetative state for one reason or another, and none had an advance directive or had a surrogate. And they stayed on life support for many, many years. Their families went to court. And really, you don't want that to happen to you. And teenagers think, oh, I'm immortal, but if things happen, like these girls were 20, and anybody over 18 can create an advance directive. And the most important thing, I think, when you're that age, 18, is maybe picking someone who can make decisions if you should be in a coma. I think that's more important than picking end of life wishes, because you're not there yet. You're young. But you do want somebody to be able to go to the hospital and make decisions for you if you can't. These rights were all codified in the Patient Self-Determination Act in 1990. It was enacted in 1991. And it gives patients a lot of rights. It makes hospitals tell them certain things. And it really brought into the light advanced care planning and why it is so important. And along with that is choosing a surrogate who can speak for you when you can't speak for yourself. And I just read an article that Congress, now this was in 1990, so that was quite a while ago, Congress is revamping the law to give patients more power over their healthcare decisions. So they've looked at this law and they've seen what's wrong, and now they're trying to revamp it. But I think they have a lot of other things on their plate right now, so I don't know when that's going to happen, but I'm sure it will at some point. You can always refuse treatment, and a lot of people don't understand that, but a mentally competent adult can refuse any unwanted medical treatment, including life-saving treatment. So if you're brought into a hospital and you don't want a feeding tube, you can just say no. If that's going to keep you alive, it doesn't matter. It's your choice. So you can refuse or accept. You can say, I want that feeding tube, or I don't. Where all of this kind of started was under informed consent and patient autonomy laws. And more than 100 years ago, Benjamin Cardozo, he was a New York judge. And I really hate reading slides, but sometimes a slide has such important information on it. That's why I do it. Every human being of adult years and sound mind has a right to determine what shall be done with his own body. And a surgeon who performs an operation without his patient's consent commits an assault for which he is liable in damages. And this is kind of the basis of my whole talk today. You can't do something unless you have the patient's consent. And then if you do something without their consent, now it's an assault or a battery, depending on the state and what they call it. And that case was the Schlorendorf versus the Society of New York Hospital in 1914. And in 1908, Mary Schlorendorf was admitted to a New York hospital, and I believe it was a public hospital, where she had stomach issues. And so she goes to the doctor, she goes to the hospital, and they say, you know, we don't really know what's wrong, but we can't figure it out unless we do some exploratory surgery. She agrees to that. She said, sure, you can see it, but I don't want you to do anything else. So in she goes. Guess what? They take out this fibroid tumor, which might not have been so bad, but in doing so, something happened and she got gangrene and she lost 3 fingers. So she sued, and unfortunately, she sued the hospital, not the doctor. And the hospital was a public hospital and they couldn't be sued. If she'd just sued the doctor, she might have won. But this case has set a precedent for over 100 years about informed consent. You need to tell the patient what you're going to do, what you expect the results to be, and get their permission. That's really what it's all about. And this particular case led many other states to form informed consent laws. They put their laws on the books, not nationally, but state by state. So doctors, medical facilities, nursing homes, you name it, they have a duty to follow advance directives and surrogates. And advance directives, legally recognized documents, they have a strict duty to comply with legally recorded wishes in an advance directive, in a MOLST, in a POLST, a DNR order. And doctors and other medical providers are also under a duty of care to follow the surrogate orders and decisions about your care. And sometimes that happens where they have an advance directive, they ignore that, and then the surrogate is like screaming in their face, no, she's a DNR, she doesn't want CPR, she's 95 years old, but they go ahead and they do it anyway. If someone acts against an advance directive or a surrogate, they can be found culpable criminally, civilly, and administratively, and may be required to pay damages. So not only is it criminal, because battery could be a criminal act, it's civil where you can get damages, or a doctor could lose his medical license for not following the advance directive and the surrogate. And there are some exceptions to the duty, and they don't have to follow your advance directive if it goes against their conscience, their ethics, their religion. Whatever the medical decision is, if it directly violates any of those things, then they don't have to do it. They don't have the necessary skills. You certainly don't want a doctor who has, 5 minutes of training to do some surgery on you. And hopefully they would say, no, I can't do it. I'm here, but sorry, I don't have the skill to do it. If the provider considers your wishes to be medically inappropriate or ineffective, which would result in futile health care. You're asking them to do something and they're just going, no, sorry, can't do it. It would be futile. So they do have the right to say no. If it goes against the facilities policies, and if you go into a hospital, particularly those with a religious affiliation, the hospital may refuse to honor some of the provisions of your advance directive. And that kind of brings you to the next one. If you violates healthcare standards of the provider or medical institution, so say you're in a hospital that is a religious hospital and you want to be taken off a ventilator, well, they may question that. Or you don't want antibiotics, that's a big one. They're just going to give you antibiotics. So they can say, no, we're not going to follow your VSED, which is voluntarily stopping eating and drinking. They can say no to that. However, if they refuse to treat you, they must immediately tell your surrogate that they're not going to treat you. They can't just leave you hanging in the emergency room for 2 days. They need to tell you, no, this is against my religion or whatever, and I'm not going to do it. They need to ensure that and the surrogate knows, that what care you're entitled to. Like, yeah, you can get this procedure or that procedure. I'm just not going to do it. And if they're not going to do it, they should refer the patient to either somebody else in the hospital that will do it or to another facility. And if it's another facility, they should help transfer the patient, which sounds easy, but really a lot of times the other hospital doesn't want to take this patient, or there's some issue around the patient maybe not making it to the other facility. So, but they're under an obligation to try to help transfer the patient. And if they keep you there and they go against your advance directive or your wishes, then they may be liable for damages. So this is kind of a longish section because I get this question a lot. Why do so many advance directives fail? And they fail. I hear about it all the time. First of all, the AARP says 35% of advance directives can't even be found. So you did one, but you don't know where it is. So keep it handy. Give it to your doctor. Give it to whoever in the hospital will download it to your medical chart. Other people aren't aware you did one. People don't like to talk about death. I know in this crowd, that's probably not true. But if you haven't told your family you did an advance directive, how are they going to know? So let your family know where it is, where you keep it, and never keep it in a safe deposit box. The surrogate might be unaware that they were chosen. So you did your advance directive, you picked somebody, and you didn't tell them. And Helen Bauer has a podcast called The Heart of Hospice. And she told me the story that she was driving one day and she gets a call from an ICU and they said, how do you want to treat this patient? And she said, I don't know what you're talking about. And they said, well, she named you as the surrogate. And Helen said, she knew this person in kind of a peripheral way, a family kind of thing, but she didn't know the woman. She never had a conversation about death with her. So this really threw her for a loop. Even though she was a hospice nurse, it was very, very difficult for her to deal with this situation. And it's kind of a cautionary tale. Maybe you should make sure that the surrogate you choose wants the job because it is a big job and there's a lot of responsibility. The surrogate is unavailable when they're needed, and who knows why that is. They don't answer the phone. They're backpacking in Africa. Whatever the reason, they're just not available. They're not qualified to make the decision. Medical staff won't follow something if they think this person really doesn't have a clue. Excuse me, a surrogate refuses to follow the directive, and This can happen when you thought it was a good idea to be your mother's power of attorney, but now you have a choice. You have to disconnect her from life support. And so that may not be something people can wrap their head around. And so they may just say, nope, not going to do it. That may be what she wants, but that isn't what I want. Family members disagree on what is the best care. And the biggest source of conflict at end of life is in an ICU when families get together and they can't agree what mom wants. Someone who hasn't seen the patient swoops in, and that's actually a term they use. They swoop in, they give their opinion, they tell what should be done, but really they haven't seen the person in 5 years and they have no idea what they want. They haven't had any conversations with them. So if you have an advance directive with a named surrogate, that's the only person who has the right to follow your advance directive and your wishes. The surrogate's understanding of what you want differs from what the patient meant. So you want to avoid vague, subjective, boilerplate terms, and I'll give you 3: extraordinary efforts or heroic measures. Pacemakers used to be extraordinary, but now they're very routine. But they're difficult to turn off. And there's sometimes you get a fight, you get pushback. We don't want to do that. And so if you're incapacitated, you need to spell this out. Do you want a pacemaker? Excuse me, do you want antibiotics? How about resuscitation at 80 or 90 when the odds are you likely won't survive, or if you do, you won't have any quality of life, or you may even have brain issues. So under what circumstances would you want a feeding tube? Once they go in, like pacemakers, they're very difficult to remove. And they're especially difficult for the family member because this is how they're feeding mom. And now guess what? They're being asked to remove the feeding tube. So that's a very difficult thing for people to do. So spell out your treatment and non-treatment wishes in very clear and explicit language on your advance directive. Quality of life is another thing. And what does it mean to you? At what point is quality of life so poor that you just don't want to continue? Is it when you don't recognize family members, when you can't toilet yourself, when you go to a nursing home? It could be many, many things, especially in dementia. When you reach a certain point, at what point is your quality of life so bad? The trouble is the line in the sand is different for everyone, and it can change. It can change with a person. I've seen it a lot, when this happens, that's it, I'm checking out. But then that happens and they don't check out, like all of a sudden the quality of life maybe not so bad after all. Lastly, avoid no hope of recovery. If you say that, that's it. If there's no hope of recovery, I don't want this, I don't want that. But that's so vague. It leaves the door open for a doctor or a surrogate's interpretation. And people will say, there's always hope. There's another miracle. I hear that all the time. Oh yeah, they just came up with this new cancer treatment. I'm sure that's going to work. And then they provide unwanted or futile treatment just because you haven't said, what does no hope of recovery mean? And finally, an advance directive can fail if the doctor disagrees with it. And we just talked about that. If he's morally opposed to honoring your wishes. So you get into a hospital, and we just had a whole little discussion about that. So here are some ways to ensure your advance directive is followed. Create an advance directive using explicit language about treatment choices and end-of-life goals. You really need to spell it out. More important, choose an effective surrogate who will fight and follow your wishes. You don't want somebody that's wishy-washy. You don't want somebody that really wants to do what they want to do and not what you want to do. So that's what I mean by effective. Somebody who's going to follow your wishes and fight for you. Video your advance directive on your phone from a professional service that does this. And that's just smart. I think there's only now 2 states that allow a video as an advance directive, but every other state, it's a video would be used as a supplement to the advance directive. But the beauty of it is you hear mom say, I want this and I want that, and this is my surrogate, and you ought to listen to this person, and when they had capacity to say it, and that can really go a long way to saying to the swooper, you know, this is what she wanted. So what you're saying is all wet. We don't want to hear it. This is what she wanted, and she put me in charge of making those wishes happen. Have many conversations, not just 1 or 2, many conversations with your family, with your surrogate, with your doctor. Make sure everybody knows what it is you want. And one of the women, Nancy Cruzan, she was in a car accident and ended up face down in a ditch, and they revived her and they bring her to the hospital, and she's on life support for like several years, many years. And I think she had the feeding tube, and they said, okay, her parents, let's try to take her off that. And they go to court, and the court says, no, sorry, we don't know that that's what she wants. And they went all the way to the Supreme Court, and the Supreme Court said, no, you can't be her surrogate because she didn't pick you. So the court sent it back to the lower court, and the lower court was able to accept testimony from her friends. You know, you're in a break room, you're working with a bunch of people you like, and you have, and why they had an end of life conversation, I don't know. They probably heard about somebody on life support and said, and she said, I never want to live like a vegetable. And so she said it to her friends said it in court, and then her parents were allowed to take her off life support. So that's how important those conversations are. Carry a medical power of attorney and advance directive with you. I just had a call the other night from a couple who his mom was in a nursing home and she had trouble breathing. So the nursing home called the EMTs, and they're on the phone with the aide at the nursing facility. And she's telling the EMT she's full code, and the people are on the phone saying, no, she isn't, she's a DNR. And I mean, they got to the hospital and they didn't have the power, they didn't have the medical POA or the advance directive. Her son was the POA. But long story short, the hospital realized what was happening and they listened to the surrogate. They said, oh, okay, we'll extubate her. But by then she was already on a vent. And the saddest part of that is they bring her up to a room. She's on a ventilator. She can't talk, but she can see and she knows what's happening. And she looks at her son and it's like, why have you done this to me? So make sure you carry those documents with you. Don't rely on the hospital to have them. They may be buried in some medical chart. You need to be proactive about your medical care and with your advance directive. And if you have a problem, call me. This is what I do. This is what I love to do. That couple I just told you about, they wanted to know what should we do. And I tell them, you know, the legal options, but they were already that far ahead of me. They weren't going to sue the EMT and they weren't going to sue the doctors because the EMTs told the doctor she's full code, but they are going to sue the nursing home because they went back there that same night and they had the aide look up her chart and sure enough, there it is, black and white. She had a DNR order. And so if the aide had taken 2 minutes to go look it up, none of that would have happened to the mother. And I think she lasted about 2 weeks or so. And it's a long 2 weeks to watch somebody suffering. So here is kind of the meat of this whole presentation: wrongful prolongation of life cases. And they used to be a long time, well, still, when like a baby would be born, it was, and it had all kinds of health issues, and the parents said, no, we don't want that, and it would be called wrongful life. Now it's wrongful prolongation. It's the end of life when you're prolonging life, and usually it begins with unwanted medical treatment. Physicians, they're focused on saving your life. They don't always consider legal implications. And in most of these lawsuits, a lower court has already thrown out the case, happened all the time. claiming the provider or the facility had immunity. However, higher courts are now reversing and allowing these cases to go forward. And I read an article the other day about these cases, and the author, who's an expert witness in these cases, said they're surging all over the country because people are waking up to, it's my choice, not the doctor. And once they're allowed to go forward, the two that I spell out for you, imagine you're in the jury and you hear this case. Insurers and legal teams on a hospital don't want these cases to go before a jury. So typically they settle ahead of time. And what's really shocking to me is how blatant the wrongdoing is in both these cases. They could have done it right, but they didn't. They just did what they wanted to do. So Dad Pope, who's like one of my heroes, he's an ethicist and a law professor. He has written extensively on these types of cases. And he said patients in the US have been subject to an ever-growing avalanche of unwanted medical treatment. And that's because we have the medical treatment. Oh yeah, we just invented some new gizmo to keep somebody alive 5 seconds longer, and let's try that. And so just because we have the ability to keep somebody alive doesn't mean we should. And so it's unwanted medical treatment, economically, ethically, and legally wrong. Unwanted medical treatment constitutes waste, often fraud and abuse of scarce healthcare resources. You're keeping somebody else alive, and now they're in an ICU, and now somebody who really needs the ICU and could survive can't get in there. I was talking to somebody the other day, and she was brought to an emergency room, a substandard hospital, I won't say where, instead of the good hospital, because they were full up. And I mean, we do have scarce resources. It's a serious unwanted medical treatment, serious violation of patients' autonomy and self-determination. It's up to the patient. It's up to the surrogate. Courts and agencies have increasingly imposed penalties on providers who deliberately or negligently disregard advance directives or DNR orders or MOLS, and I'll talk about those in a bit. If someone acts against a directive, again, that's criminal, civil, have to pay damages, we'll see. Most of the time they settle, or sometimes a jury decides. Or they could lose their medical license just by not listening, basically, is what it is. So here are the two kind of causes of action that these cases are brought. Either medical battery or medical malpractice. And medical battery, I have two cases, and it's one of each. Each has a different legal claim or cause of action. In the first, the plaintiff sued for medical battery, and it's the intentional touching by a medical professional in a medical setting. And the key is the doctor intended to touch. That was the part that was intentional. You don't have to prove he wanted to cause any harm, even though he did cause harm, but that isn't what you have to prove. So an example of that is Mrs. Schlowendorf. She just wanted exploratory surgery, and she ended up having a tumor removed that, without her consent, that caused damages, caused her harm. He intended to touch her, and so it was medical battery in that case. And then we have medical malpractice. I took a course in this in law school, and oh my God, it was the most fascinating course that I took in law school. And you have to have these four things in order for there to be medical malpractice. First, you have to establish a duty. There's a professional duty of care on the part of the provider, owed, or the facility really, owed to the patient. And then you have to prove there's a breach of that duty. Excuse me. And then you have to prove, I mean, everything leads to the next thing. You have to establish the breach caused the injury. So, I would say, I would argue that Mrs. Schlowendorf was medical malpractice as well, because the breach of their duty caused her to have her fingers amputated. I mean, it was a direct causation. And the damages are both economic and non-economic losses suffered by the patient And in most of these cases, the family is who comes forward and files these lawsuits because they've had to watch this, the person that they love suffer and be revived more than once, come back from the dead when they were already grieving for this person and now they have to grieve for them again, sometimes years later. Sometimes they keep them alive for 7 or 8 years on life support. And so that's really one of those non-economic losses, besides the economic, the cost it takes to keep someone alive in a nursing home, on a feeding tube, in a bed. I mean, how much are nursing homes? $5,000, $6,000, $10,000 a month. And the family has to bear the brunt of that. So that's why I think, because as prices go up, they're taking a look at, who's at fault here. Case number 1, and this is Mrs. Busilla Stevenson, 91 years old. She did everything right, absolutely everything right. Everything I told you to do, she did. It's probably the most famous of the cases because a lot of these cases settle, but you never hear about them. And one of the stipulations in the settlement, her granddaughter was her surrogate. She said, I want this case, I want everybody to know about it. So good on her, because this is probably one of the most famous. It's one of the first. She was 91. She completed her advance directive. She'd had some health issues, but she had clear and specific instructions about ventilators, and because she'd been on one before. So she said, no, I don't want to do this again. And I'm old and I have health issues. So she appoints her granddaughter, Jackie, as her surrogate. And she informed all her family members she didn't want to be kept alive on any machines, including a ventilator. So I just have to say, some of these cases just make my blood boil. And so I get excited and my voice volume goes up. So pardon me for being passionate about these, because it's like I'm rooting for these people. Good for you for fighting for your rights. So she gets brought into the emergency department, then the ICU for breathing. And the other thing her granddaughter had stated was, if you're going to do anything, give me a call. I want to know. Contrary to her wishes, the attending put her on a ventilator. He intubated her and put her on a ventilator, exactly what she didn't want. And the nurses who knew, they'd read her advance directive, they cautioned him and said, you should call the granddaughter. Nope, he said, and this is a quote from his deposition, he would put the vent in, tell the family later, and remove it if they objected. So put yourself in the granddaughter's shoes. Your beloved grandmother is on a ventilator against her will, and you have to authorize the doctor to extubate her. In other words, to pull the plug and watch her die, because they put her on a ventilator, which they shouldn't have done in the first place. And the judge in this case said it's the will of the patient or the designated agent and not the will of the healthcare provider that controls. It's up to them, not some doctor who thinks he knows it all. Here's their medical, their battery claim. And they had other claims too, breach of agreement, ordinary negligence, but medical battery, and I think intentional infliction of emotional distress. I think that came in when the nurse said, you granddaughter, and he didn't. And so they put her under all this emotional distress needlessly. So that was one of the things that they sued about. And so she got on the ventilator in 2012. The case was settled in 2016, 4 years later, settled for over $1 million. And that sounds like a lot, but her lawyer, these cases, there's a lot of paperwork and filing motions and getting thrown out of court and having to refile in another court. And so there's a lot of time and money involved. And that's kind of another interesting thing about these cases. And I've seen this a lot, is that the couple I was just telling you about, she was only seeking $200,000 in damages. And so that probably sounds like a lot of money, but she was in the hospital and she had all this treatment done and she had to hire a lawyer and blah, blah, blah. So the people are not looking for a big payday here. None of them are. They want an apology. They want somebody to step up and say, you know what, I screwed up and I'm sorry. They want the money to cover any extra expenses, and there are going to be extra expenses. I mean, she had to take time off from work to watch her grandmother die. So really, she should be compensated for that. And they want it somehow a procedure put in place so it doesn't happen to another family. That's really, I've seen that time and time and time again. That's what people are looking for. But what happens is the hospital and the insurance company, they all dig in and they double down on, we didn't do it, it wasn't our fault, we have liability, we have blanket immunity. And so that drives up the legal costs, which drives up the settlement costs. And if they'd have just owned up to it in the beginning, they wouldn't have had to pay so much. Case number 2, Dr. Greenberg. And this is another one of those that you just want to slap people, really. This poor guy, he was diagnosed with early onset Alzheimer's at age 61. He was a dentist in, I'm guessing, New Rochelle, New York. And so according to his living will, he made his wife his medical power of attorney. His 2 sons were adult sons, were involved in his care. No CPR, no tube feeding, no antibiotics. When he reached a certain level in his dementia, he reached that level. He was in a nursing home and I think he fell. They bring him to the emergency department and he gets sepsis, which I just wrote an article about that. Antibiotics, if you have sepsis and you don't get antibiotics, you die pretty peacefully in a couple of days. So I'm told. I've never died, so I don't know, but from all accounts, it's the old man's friend. It's like pneumonia, sepsis is form of that. So the doctor gives him all kinds of curative treatments and antibiotics, brings him back to life. They also had a MOST, which is a medical order for life-sustaining treatment, signed by a doctor, signed by the surrogate, because by then he was, he had no capacity. And it also said comfort care only. What don't they understand about comfort care? So he's alive. I forget it. It was like for another month, he was alive and they sued. And according to the New York appellate court, it happens. They take it to one court, it gets thrown out. Another court gets thrown out. Now the appellate court, the highest court in New York, says a competent adult's right to refuse medical treatment, even when refusal may result in death, is well established by case law. I don't think it gets any clearer than that. So their claim was medical malpractice. The defendants breached the standard of care by administering treatments without his consent or without his surrogate's consent. They were acting in direct contravention of the wishes expressed in his advance directive, reaffirmed by his healthcare agency, going right against his advance directive. They failed to follow his MOST. His MOST was a medical order. So a doctor signed this thing and he wanted comfort care. He didn't want any of this other stuff. It said no antibiotics. So he went against that. I mean, is it just me or this is why I'm so passionate about this, because, it's in black and white and they still ignore it. And his family endured pain and suffering, and him too. He was in the fetal position. And I mean, he, on some level, I really believe dementia patients, whatever level that is, they know something's happening that they don't want to happen. So imagine you're his family watching him die for a month. Not just die, but suffer. So the defendants first appealed. Oh yeah, they always appeal because they drag it out. But then they withdrew their appeal in June of last year, and Compassionate Choices had written a brief and they said, and this is one of those things that, deserves reading. This victory ensures that advanced planning documents are legally enforceable and will be respected by doctors. If they are not, individuals can hold providers accountable for violating their healthcare decisions. And so I actually spoke to Thad Pope, and he said he had checked and the case is progressing. I would have thought after June 2022 that they would have stepped up and settled right away. So it's been more than a year and almost a half, but they'll get there. I know they will. I have no doubt about that. So here's some other cases. This is the first jury award, Knoffel versus St. Peter's Health, $409,000. He didn't want to be resuscitated. He wore a wristband. It was in his advance directive. His surrogate said they resuscitated him twice, not once, but twice. Magny versus Humboldt County, California. County officials took the rights away from his surrogate, who was his wife, and gave him some treatments that he didn't want. And so they committed fraud. They were indicted on this, but I don't know what happened to them because that was 2019. So in the judges said, use phrases like beyond the pale to describe the county officials, appallingly inadequate, lack of candor. Like, in other words, they lied. Vaughn is an Alaska case that has not settled, but it's moving forward in the system because the hospital assumed the decision-making away from his parents, who were his surrogates. So the doctor said, you know, good faith alone is what the judges said. It does not provide immunity. Just because you think you're doing a good thing, no, sorry. That isn't what he wanted. And the last one is kind of an old one, but it was a Maryland case, and the husband authorized a MOLST form for his incapacitated wife. And these MOLSTs work in conjunction with an advance directive, but they are the higher authority because they spell out exactly what you want at end of life. They're very short, and they cover comfort care, full care, limited care, CPR, no CPR, DNR. So antibiotics, no antibiotics. That's what I mean. Like it's so concise. So he had a MOLST form and they performed CPR. She was not CPR. She was DNR. And they used electric shocks. They broke some ribs. They injected epinephrine. And I mean, they revived her. And so they ended up settling. But really, why does it have to go that far? And I don't know if you can see this, but I put a link to Thad Pope's website on unwanted treatment cases. He has a great website. Just Google Thad Pope and unwanted treatment cases, and you'll come up with a list. He has them listed by year, and there were like 5 I didn't even know about, like, because he's an expert witness in these cases too, along with the other guy. And so that's really a good place to read some of these things. And you can drill down, to, get past the legal mumbo jumbo until they'll tell the story. This is what happened. And I mean, everybody has a right to dispute that, but just saying. And this is a case from a couple that called me, Doyenne and Bob. He, again, Alzheimer's, did his advance directive. He got so bad, she put him in a facility. It was a very small place. A woman owned this house with, I think, maybe 15 rooms in it, dementia care rooms. So it was a locked facility, and it was during COVID. So she didn't really get to see him, but she knew what was happening. And the doctor refused. He kept ordering all these tests and x-rays and giving him meds. And long story short, I worked with her probably for 8 or 9 months. And every time she'd email me, it was another thing about, well, they did this, they did that. And so I had to write a letter, send it registered to the doctor in the facility, who had signed the MOLST, by the way. So he knew this guy only wanted comfort care. That's all he wanted. He didn't want anything else. But he, again, in this case, we were kind of thinking that maybe they were trying to keep this poor man alive so that they could collect the monthly money, because it wasn't cheap to keep him in this facility. I hate to think that, but what other reason could he have? And then she wanted him to go into hospice. That was a battle. And finally, they picked a hospice 25 miles away, when there was one in town that I checked on that had great reputation and would have been much better. But so why would he pick somebody 25 miles away? We don't know. So anyway, she got the letter sent. They agreed. They started to wean him off the meds he was on. He was still on meds after 10 months. And he ended up dying in January 2022. And so that's the kind of thing I help people with. And the whole time, Fenn's attorney was in the background. We both read all of her documents. He knew what was going on. He consulted another doctor about, what is this, him going against the most? And so they're ready to step up pro bono. They step up pro bono in these cases. And I mean, you can't ask for more than that. Today's top 10 takeaways, and I have a flyer for that, Gail, that I will send over. First of all, know your rights as a patient and a healthcare surrogate. Both have rights, know what they are. No, doctors no longer have blanket immunity from liability when they don't follow your advance directive or your surrogate, legal surrogate. Medical staff must honor your advance directive unless they have a conscientious objection, and that's possible. Must notify you or your surrogate and help transfer to another facility or another doctor. Create an advance directive using explicit language. You really need to spell out your treatment wishes and your end-of-life goals. Video your advance directive so people can hear your voice, so they know what you want. This is mom telling you what she wants. And what she doesn't want, what are the point? Choose an effective surrogate who will fight for your wishes. Always carry the advance directive and the power of attorney with you, so you can just shove it in their face. No, she's a DNR. What part of this don't you understand? And there's another weird thing. If somebody's been brought to the hospital a number of times, their DNR status does not transfer. It's a weird thing in their medical system records. So if you have a loved one going to the hospital more than once, and they're a DNR, it's in their chart, but somehow it doesn't transfer to their medical record at that moment. So you need to check, because a friend of mine who's in the medical profession told me her story, and that's exactly what happened. And so you need to say, tell me what the code status is. And if it doesn't agree with what your person wants, then they need to change it. And call me if you need help. I'm available. As you can tell, I love these cases. Oh my God. And Fenn's lawyer is available pro bono to help members fight for your rights. Final Exit is here to help. Here's their, this is their main number. Check out their website, lots of tabs. This is my information, 800. I have a dedicated 800 number that goes to me, a dedicated email. This is my business. You can reach me this way too. That's my cell phone number, probably the quickest and easiest way to reach me, and I text. Fenn offers, a trial membership, so you can test drive, and just send them an email at info@finalexitnetwork.org and say you attended the Before I Die Festival in October 2023 and would like to receive 4 complimentary magazines. Now, they send you a digital magazine, but they're just, everybody's digital now. And I write a lot of articles that get in there about end-of-life topics and surrogacy. So they're really excellent magazines, and it's a great way to see what they do. And if you want to become a member, membership's like $50 for an individual, or $750 for it's a lifetime membership for a couple. And they need money to operate, because they pay me, I have a contract. They pay a couple of other people, but mostly it's volunteers. But it takes a lot to run an organization this size, because we have almost 3,000 members. So you have to mail out the magazine. That's not free. And you get a glossy magazine once a quarter. So there's a lot of expenses involved. So please consider becoming members if you're not already. And if you are, thank you. The content here is only for informational purposes. It's not legal, medical, insurance advice, none of the above. Not part of this program. No part of this program. You can't copy it, can't distribute it. I think we might have time for a couple of questions or comments.
I know of a lady that from our church that she gave the directives and all these forms to her niece. She's single. Her only son is in prison, so she pretty much said, "I need help." So the niece and the husband are living with her, and now they're telling her, "You have no rights. You can only follow what I say because you gave me all your directives." And this lady is so very, very conscious of her life still, and now she feels like she's lost.
Okay, well, first of all, there's two things. One is a medical power of attorney and the other one's a financial power of attorney. And if she gave them her financial power of attorney, then basically they can do whatever they want. But medical, as long as she still has capacity, she can kick them out. She can say, you know what? I want to pick somebody else, maybe a lawyer who will step up and act as her medical power of attorney. There's people all over the place that will do that, especially in New Mexico. That isn't right. I don't know what it is they want her to do. I don't know the circumstances, but if it's financial, then that's a different story. And that's hard to back out of. Once you give somebody that, they can sell your house, they can sell your car, they can put you in a nursing home. There's so many things they can do with a financial power of attorney. But medical, as long as you can still make, a doctor says, well, she has capacity. She knows what I'm saying. And there's a whole rule around what constitutes capacity. Then she can make her own healthcare decisions.
Thank you.
Maybe you should get your minister involved. Like if that's, I don't know the circumstances and I'm just talking off the top of my head, but something like that could be elder abuse. You don't know why they're saying these things to her. They should be looking out for her and not telling her what to do.
Thank you, Althea.
Anytime, Gail. Thank you so much for having me. Always appreciate it. Wish I could be there, maybe next year.
Okay.
All right.
Thank you, guys.
Take it easy. Yep.
And thank you, Keeper, for helping us do this. We couldn't do it without you.